So let's take a break for about 10 minutes and we'll be right back. Okay, we're back from the break now, and thank you very much, folks, for arriving here. And this is Labor Day weekend, and we got a kind of skimpy crowd, so we're still going to make out all right. One person, if we have one person here, it's a majority, because it's a citizen. The lady in the back of the room just brought an initiative measure to be submitted to the voters here, and let me read it, what it says. Judges, limiting immunity. Initiative constitutional amendment. Eliminates immunity from civil liability of state judges, magistrates, commissioners, arbitrators, and judicial mediators for deliberate violation of law, fraud, conspiracy, intentional violation of due process of law, deliberate disregard of material facts, judicial acts without jurisdiction, unreasonable delay of case, or deliberate constitutional violation. Established 3 25-member special grand juries empowered to indict and through a special trial jury convict and sentence a judge for criminal conduct, determine if a judge may invoke judicial immunity in a civil suit, and permanently remove a judge who receives 3 adverse immunity decisions. Summary of estimate by legislative analysis and director of finance of fiscal impact on state and local government. This measure will result in cost to the state of about $17 million for the operation of special grand juries. These costs could be partially to fully offset by a number of sources specified in the measure. To the extent that the measure results in additional civil cases being filed against judges in courts, the measure could also result in unknown additional costs to the state for support of the courts. So they have to hire new judges. So there's this initiative memorandum is in the back. If those people want to go back and sign it after the break, after we finish here, before we leave. So everybody's trying to get the judges to toe the mark. And judges are scared. Steve, why don't you send one of these to Judge Messer? And Judge Kikita?
He'd probably forward it to the bomb squad if it had my name on it. Not that I would do something like that, but he would be concerned, I feel sure.
No, why don't you go take the measure down to the courthouse and circulate it around this court and ask all of the bailiff and everybody to sign it.
Richard, I'm trying to stay out of jail. It's all the same to you.
Okay, now we're back. One of the key things we like to educate people in is to take the rocks out of our wheelbarrow and put it in the government's wheelbarrow. I've got over 1,000 court cases say the prosecution has the duty to prove every single element of the case. They never do. What's the first thing they got to prove? What's the first thing the prosecution has to prove?
Who you are.
You're a person. They have to prove you're a person. Now, how do you prove you're a person? You admit it. What is a person? A person is no good thing. It's not a citizen. They can't prove I'm a person. They can't even prove I'm a human being.
A person is a natural person.
They can't prove I'm a natural person either.
They think they can.
An apple is a red apple.
There you go.
A human being. We've got a lot of new faces here tonight. So let me explain what a human being is. A human being is a monster. And a monster, if you go back in the Ballantyne's Law Dictionary, 1948 version, published by University of Southern California, USC, it specifically states that a human being is a monster, and a monster is a human being by birth, and originated in the 12th century when the kings and knights were going across Europe. Along the way they fathered a few children. And to keep those children from inheriting the sovereignty and the thrones, they called them human beings, being like a human. But they do not have the right to hold sovereignty. They cannot be sovereign. That's right out of court cases. Comes out of Blackstone's the 12th century. So that's why the federal government and the state government both use the term human being. No place in the penal code anymore do they use the word citizen. They used to. In 1972, there used to be section 228 of the penal code. It said any citizen who fights a duel cannot vote or hold public office. Section 232 said any person who fights a duel cannot vote or hold public office and has to go to jail for a year, making a legal distinction between a citizen and a person. That's in the penal code.
Yeah, well, you burned that one for us, didn't you?
Yes, I did. I did that on a couple seminars here in California. I did it on TV and radio and etc. And the government, legislature removed the two sections as no longer operative because people don't fight duels anymore.
Duels are legal now.
But it's still there. That's the intent of the law, is still there. And there's the Argent case. The Argent is another case that makes a legal distinction between the word citizen and person. It's fairly recent, 1987 I think it was. The Argent case. I can't remember all the sites. I'm good but not that good. So understanding the difference between person and citizen, slave, no good name. And how do you bring this to the court's attention? Very simply, you file a judicial notice. You can file as many as 30 judicial notices into court and make the court argue those judicial notices. File a court that I'm not a slave. Judicial notice that I'm not a slave. File a judicial notice I'm not a person. File a judicial notice I'm not a human being. File a judicial notice that I have no contracts. File a judicial notice, write this down everybody, the new people, nisi prius. N-I-S-I-P-R-I-U-S. Nisi prius court. All courts in this land are nisi prius courts. They're contract courts, revenue courts. And you have to give the court notice that they are nisi prius court and they can't move forward until they prove that you have the contract and produce a contract. You can do that. We've had judges accept it. We had a judge in Santa Barbara said, yes, we're in nisi prius court. But my buddy, he didn't. Then the judge went on to the next judicial notice. And he didn't stop. Remember that, Steve? Time out. Should have stopped right there. But he didn't. He moved on to the next one and he glossed over his head and he lost it. But he had the court. He should have stopped right there, proved the contract. No matter what you do, if you do it right. Non-assumption. File judicial notice, non-assumption. Non-assumption means no contract. We do everything by judicial notice as a motion to dismiss. You can file as many motions to dismiss as you want. And after you're convicted, you can keep filing as many motions as you want. Coram nobis. You can do coram nobis up from now till the end of time. Till the judge orders you not to file anymore. You do writs of certiorari on every single issue. Every time the judge does a mistake, you think is a mistake, do a writ of certiorari on them. There's many different ways to keep the ball in your court and make them start proving everything. That's the key element to make the other side prove every single element. First they got to prove. Officer, would you tell me what you saw? The officer's on the witness stand. Officer, would you, under penalty of perjury, will you tell me what you saw? Well, I saw this motor vehicle. Objection. Define what motor vehicle is, according to law. Since you saw it, that's only hearsay what you saw. Let's define it according to the law. What is it? Well, I was told that everything four wheels is a motor vehicle. That's not what the court said. What does the court say a motor vehicle is? What's the case name, Steve?
Geico.
Geico Insurance versus
Carrier's insurance.
Carrier insurance. A motor vehicle means commercial, according to the California Vehicle Code. So he's got to prove you're involved in commercial activity. Officer, was I involved in any commercial activity the time you stopped me? No. Was I driving a tractor, trailer rig, or anything, bus or anything? No. You weren't involved in anything commercial that I know of. Thank you, officer. Next question. Officer, did you go to the police academy? Yes, I did. How long was your police academy? 6 months. Did they teach you the laws that you were enforcing? Yes, they did. Do you think you're an expert in enforcing those laws that you were taught to enforce? Yeah, I know the laws I'm supposed to enforce. Thank you. Now you got it. Bye, officer, you're incompetent. Next question. Define, officer, in your own words, what the law says. Since you claim you're an expert, I'm just merely qualifying. Prosecution's going to be jumping up and down, screaming bloody murder right now, about now. I mean, objection, Your Honor, objection, Your Honor. You can shut them up real quickly. Your Honor, I don't quite understand these objections that the prosecutor's bringing forth consistently. Is the prosecutor asking for a Nuremberg defense for this officer? Hitler's Gestapo was put people in the ovens and say, I was just merely doing as I was told. Cali tried it and couldn't get away with it. Is this, are you, Your Honor, going to allow this officer just to get away with it, that he was doing merely as he was told? That's what this prosecutor's wanting you to do. They allow the Nuremberg defense in this courtroom. And especially if the judge is Jewish, you won the case right then and there. See, learn to shift the burden. Take the... I used to be one of the nastiest persons because I was going into court. I had the biggest head. My head was this big. I walked into court, was going to prove everything. I've since learned my lesson. I don't prove anything. I let the government prove everything. They have to prove every single element. But you have to make them do it. We can't do it. So you have to make them do it. And how do you make them do it? Make them prove every single element, regardless of what it is. They have to prove, like Cece was saying, the Slater case. That's a Delaware case, 1982. I give it out every Sunday. USB Slater. It's one of the key cases. The courts always tell you the truth. Consistently tell you the truth. But you just don't understand what they're saying. See, as long as you understand what the courts are saying, you're going to be a winner. Someplace down the line, you know what I mean? Maybe not now. Steve's laughing at me. Maybe not now, today.
Down the line.
Down the line.
How long might that line be?
How about your other traffic case you got downtown?
Oh, that one went away pretty quickly.
That one went away. You won that one hands down, you know what I mean? He filed all his paperwork in court, and the police officer didn't show. See, the district attorney has a favorite habit. If they got a sensitive case and they don't want to, they know it's going to be a long, drawn-out thing, and they're going to have to spend a lot of time and effort with the case. But the prosecutor does call up the police officer and says, you don't have to appear in court today because we're going to settle, this case is being settled. Okay. The cop don't show. Then when the cop don't show, they stand up, the prosecutor says, police officer not here today, we can't move forward. Judge says, case dismissed. When I was an ex-cop, I'm an ex-cop. I got many calls like that. I didn't know why. You know what I mean? I was supposed to be in court at 10 o'clock. 8 o'clock, the prosecutor called. You don't have to appear in court today. Case has been settled. You know what I mean? You don't have to appear in court on so and such matter. Case has been settled. You know what I mean? I didn't pay no attention. I just went around my business, went out and wrote more revenue. You know what I mean? Made revenue. But you have to understand that they don't like our paperwork. And if you do their paperwork correctly, they're going to hate you. Believe me, they're going to hate you. They don't like paperwork that they can't get around. And always when you're doing your paperwork, don't copy somebody's paperwork, change it around, retype it. You don't white out somebody else's name and print your name in their place. That happened to me, a friend of mine. Way back in, I was in state court, no, I was in federal court. I had just filed a civil suit in federal court. And I wrote discovery up. So a friend of mine came over to my house and says, boy, these questions are good. He says, can I have a copy? I says, no, I haven't filed them yet. He says, well, I'm going up north, let me have a copy. And he says that I'm going to retype them over and put them in there. So what he did, I had all my name, my case number and everything else, and the District Court of the United States at the top of the page. So he whited out the United States District Court and printed it in to the DMV, whited out my name and printed his name on the whiteout, you know what I mean? And left my case number on there. And on the last page he left my signature and submitted it to the DMV. So don't do that. I don't like have to answering questions I don't know about. And nobody else likes it. That happened to another guy in, I think it was Phoenix, Arizona. He got some paperwork out of a guy in San Antonio, Texas. And he left San Antonio, Texas at the top of the page. And the judge asked him, what state are you in?
State of confusion.
He says, this paperwork's addressed to court in San Antonio, Texas, and we're in Phoenix, Arizona. Don't make mistakes like that. People do it. That's human nature. With the modern technology and computers, I have a BBS. If you're local, you can access all this information I'm talking about at my BBS. I'll give you that phone number. It's area code 818-888-9882. It's free BBS. You can just log on and just download the information as much as you want. Also, I have a free seminar tomorrow. It starts at 12 noon. It goes to approximately 3 o'clock. I will show you a few videos, and I'll give you 42 laws. I'll give you the U.S. Slater case, I'll give you Olderson case, I'll give you a whole bunch of court cases you can go home with. Starts at 12 noon to 3 o'clock if you're interested. Just call me tomorrow at my phone number. Write this phone number down. It's area code 818-703-5037. It's a free seminar. It doesn't cost you a penny. Just a few minutes of your time. You're welcome to come, and I'll just be more than happy to talk to you and explain everything to you. Then you get mad. Then you get mad as you're reading this stuff. I didn't know all this. I didn't know all this. It's consistent. The courts are always consistent. And why are the courts consistent? They have a reason. The courts will not, when they write a written opinion, they will always tell you the truth. They never lie. Why is it? Because it's there for paperwork for posterity. And it goes up. The case will be referred to. So they always tell you the truth in the paperwork. Read the written opinions. And if you want some real good opinions, take the time out, go down to the Second Appellate Court, walk into the Second Appellate Court, at the counter right there. It's over on downtown now since the other building burnt down. They have a clipboard with big hoops on it with all the unpublished cases. Read the unpublished cases. Boy, there's some fantastic stuff in there. They don't want to publish. They don't have to publish everything. And there's an attorney group up in San Francisco that's got a lawsuit going against the judges for not publishing these good court cases. They said any case that's where the opinion is written must be published, because how can people refer to them? They'll write an opinion that's way off to the side, I mean left field, way out there. And they'll unpublish it because nobody can see it. If they publish it, boy, the upper courts, they have a heyday with them. the judges would get racked to the totally end. You know what I mean? But you have to be able to understand that the courts are consistent. You can see Norm in the back. There's a book here. And you can tell you how many you want. It's called In Their Own Words. This is one of my main references book. It has all the court cases and all the sites on citizenship right here in one book. Put out by Dr. Brown. He used to come to these meetings and he used to take all the cases I talk about right now and write the sites down. And he put them in one book together so for everybody. And it's not a bad book. It's one of my main reference books. And it's got all kinds of good sites in here. Here's a court case, 1937. On appeal, Supreme Court will not presume acquiescence on loss of fundamental rights. We do not presume acquiescence in the loss of fundamental rights. Ohio Bell Telephone Company versus Public Utilities. So they don't presume anything. There's no presumptions allowed in any court trial, if you know how to bring it up. The court case says that. But they presume everything. They presume everything. They presume you're a human being until you notify them otherwise. So you have to be able to tell them there's no presumptions. You know what I mean? Got a California Supreme Court case that says no presumptions allowed. And there's no presumptions allowed in an administrative arena either. They must prove everything according to record. If they can't prove it, you win. And they can't prove anything according to their records, because it's all hearsay. Who inputted this? Got a court case. They have to find out, get a handwriting exemplar on a driver's license in order to get it in court. But you have to, one of the key things I specialize is in code enforcement and driver's license. Why do I specialize in those two things? Because if I can teach you to do the argument with the code enforcement officer, the dog catcher, or a traffic case, you can be a winner in every other case out there, because the principles are the same. The arguments are the same. I don't care whether you got a murder case or you got a major conspiracy trial in federal court or whatever it is. The principles remain the same in every trial. So you can lose a traffic ticket and get educated. Lose the fear of going to court. That the back road man, the black robe man sitting behind the bench, or a woman, wherever he or she may be. You get over the fear. Once you get over that fear, there's no problem. I had a friend of mine go to court in downtown LA on an IRS issue. This is very unique. He went into court. He says, "Your Honor, I received a summons to this courtroom, but I don't think it's me. But it was left at my door, so I'm here." And the judge says, "Are you John Smith?" He says, "I'm called by the name of John Smith, but I'm not that John Smith on your paper. I'm over here. That's somebody else on your paperwork. That's a legal entity. I'm not a legal entity. And this U.S. attorney sitting over here is trying to make a legal entity out of me, and I can't walk through walls. I'm not a legal entity, Your Honor. I am me. I'm not on not that person on your paper. I am me." And that's all he would say. And the judge looked at the U.S. attorney. He says, "Are you attempting to make a legal entity out of him?" The judge says, "He's nothing but a tax protester." He says, not the questions I ask. Are you trying to make a legal entity out of him?" He says, "He is a tax protester." He says, "Sir, you may go home. Case dismissed." That was on an IRS summons, on an order to show cause why you shouldn't produce books and records. See, he knew his argument.
Was that tax court?
Yeah, no, that's federal district court. They can't summons you in tax court. You have to volunteer. Admissions and confessions. You know, as a United States Supreme Court judge, a very famous judge, I think his name was Rehnquist. Anybody heard of him? Said, everybody in prison in America today, 99.99% of them there, are there by their own admissions and confessions. What's the first admission and confession you make? I'm that person on your paperwork. I'm a slave. Let me, did you come here in your motor vehicle? Yes, I did. Well, thank you. You've just openly confessed you're involved in commercial activity and the court has jurisdiction. If you say, no, I traveled here in my car, now, the court didn't acquire jurisdiction. You made no admissions and confessions. And we had a guy tell that to the judge, and the judge says, you would. See, they know the legal distinction, but you have to learn the legal distinction. If you don't understand the law, excuse me, how do you expect them to understand the law? And it's always consistent, no matter what it is, where it is. That's why I work traffic. I specialize in traffic, in code enforcement. I like code enforcement. Do you know that every code enforcement rule and regulation within any state in the Union today is predicated on HUD, federal rules and regulations, for commercial buildings? So when code enforcement comes out to your house, they assume it's a residence. And if you look up the legal definition of the word resident, it means business address. I can prove that to you, real simple. When America sends an ambassador to France, there he obtains a residence. That's his business address. So when you say, do you have a residence? No, I have a home. Laws specifically use certain words for a specific purpose. I don't have a residence. I have a home. You have to see. Where I live out in Box Canyon, there's a fireman, LA County fireman, bought some land up on just across on the mountain in front of me there, on the other side, and he built his own home. He's the LA County fireman. He built his own home. No building permits, no nothing, didn't ask anybody's permission, he just built his home. And in Ventura County, mind you. So, and he put a fence around it, and he said no trespassing. So the Ventura County Fire Department come around looking, you know, for fire watch, which they do up in Canyon all the time. They come up this winding mountain road, got up to the road there, and they saw this gate. They had a lock on it. He said, well, we don't know anything about this gate up here. So they got out their church key, cut the lock. They drove the fire truck in there. And he happened to be home. They said, we're on the fire watch. He said, we're checking for fires. He says, did you come through that gate down there? He says, yes. There's no locked gates for the fire department. He says, oh. He says, this is private land. You have no authority. And he says, you have a fire extinguisher in here? He says, it's none of your business. This is private land. He says, are you using city water? He says, no. He says, I'm not using city water, I have my own water. He says, get off my land. So the fire department left, got on the radio, they called the sheriff department, and they called the code enforcement officer, because the building wasn't on their map. So the code enforcement officer and the building come out there, and along with the sheriff department, the sheriff got to the gate, and he wouldn't go any further. So he blew the siren a few times, and the guy come out of his house and walked down to the gate. And he says, we're here to inspect your home. He says, you can't. This is private land. He says, I built that my home with my own hands. out of my own labor. And the code enforcement says, you don't have permits to build land up, built to me. He says, I do not need a permit to build my own home. Then they get him hauled around. The outcome was they left. And he still don't have a permit. Fire department sends him a letter every year. Can we please come in and inspect for fire dangers? And he's make an appointment. I'll let you inspect for fire dangers. You know, they write him a letter, and they'll be here at such and such time. A little pickup truck drives up there with the guy, and he opens the gate and lets him go drive around the outside edge of the fence line to make sure that there's no weeds or enough for the fire danger. But see, they have no authority on your land, and they know it, as long as you understand it. But when you think they have authority to come into your house, we had a printer friend of mine down in Altadena several years ago, Paul. He had a print shop. He had a big multi-lith printing and commercial printing house. And he had a lot of inks and fumes from the inks and stuff like that. So one day the fire department was driving down the alley. They smelled the fumes from the print shop, the ink drying. So they walked up to the building, and he had a sign that says private business. Knocked on the door. Said, we're from the fire department. We're inspecting fire hazards, and I smell fumes from ink. And he says, well, we're looking for fire dangers. He says, Paul told me, he says, well, I do not have a business license. This is a private business. I don't have a business license. But I do have fire extinguishers. I have 5 of them. He says, can we inspect them? He says, no. He says, every year I take them down and have them inspected. I can give you the permits, but I'm not letting you in my shop. He says, okay. So he went and got the inspection tags when he had them checked. You know what I mean? He said, okay, you got 5 there. You're okay. They couldn't come in there because he didn't have a business license. What does that tell you? They derive their authority from everything you do. Yes?
Was that his home, or was he renting, or what?
Well, he was renting a regular commercial building.
So even though he was renting, they still couldn't?
Right, because he didn't have a business license.
Was there any provision in the rental contract that he was supposed to have a license?
No. There was there was nothing at all in any contract. See, when you rent something, you can rent it for whatever you want. If you want to rent a commercial building and make a home out of it, like they do in New York, what they call, I don't know what they call those second
Lofts.
Huh?
Lofts.
They call them lofts. You can rent it for a home. You can rent it for any purpose you want. You're the renter. It's only when you get that license that they have the authority. It's always consistent in that way. You have to be able to understand that the license that you accept allows them to do certain things. Same way when you have a driver's license. That allows them to take your car because you're using their property. When you have a business license, that allows them to come in and inspect your property. In fact, in Ventura County, you want to have some fun? Go get a blank business license. In Ventura County, at the bottom in bold letters, everything else is fairly, but in the bottom bold, it says, application for business license at the top, right down in bold letters, right above your signature. This application is voluntary. See, they always tell you the truth, but you don't understand. You're volunteering into it. They just don't tell you what volunteer means. You got to have a business license that's voluntary. In every business license provision, the best one is Lake Havasu. It's got the best business license ordinance in the world. They've prosecuted 10,000 people over the years with Section A. It says every business in this city must have a license. Everybody been prosecuted, been convicted except one, and he used paragraph B. Paragraph B says, except those who are not required to have a license. See, they always leave a way out in every law. Go read any, I don't care which law they make. There's always a provision leaving you the way out. There may be a provision says any if there's a constitutional if this any section in this ordinance in violation of the Constitution, it does not apply. There's some words to that effect. You know what I mean? So you go in there and claim it violates the Constitution. It doesn't apply anymore. Bingo, just that simple. But read the whole thing. Sometimes I'll put that the last paragraph of the book. I write an ordinance 150 pages long. They'll make that paragraph on the last few pages, or they may make it in the first page. You don't know where it is, but it's there someplace. Then they put a severability clause in there. You mean something doesn't apply, it doesn't apply. They always leave their way out in every single ordinance I've ever read. But since I live in Ventura County, that's why I know Ventura County better. But when I saw that in Ventura County, this application is voluntary, I said, why are people applying it? It's always consistent what they do. We always try to be honest with the government. The only problem is the government's not trying to be honest with us. They want to do things their way, we want to do things the correct way. And what is the correct way? The correct way is for you to understand the law. Because they can't obey the law. Their laws specifically state they got to go through that door, and through that wall, and out that window at the same time. They have to do all that at the very same instant. That's what their law says. And they can't do it. So if you understand that, you can say, hey, you went through that wall, but you didn't go through that, that, and that, and that. You know what I mean? Bring it around to them. Show them. You know what I mean? Hey, you violated your own law. Was that 323 California Rules of Court? Was 323? Is a motion unopposed? Or 923?
In local rules, it's 914 or 915. I don't know what it is in the...
CRC, I think it's 923. It's 23 something. It says when a motion is unopposed, it must carry. So if you file something and they don't oppose it, then you say, hey, you're violating the rules of court. There's three things that most judges will not violate. I say most because we've since found out that there are a few judges that will violate them. One is the California Rules of Court, the Rules of Evidence, and due process violations. Those are the three things that they will not violate, most judges.
He got nervous about due process.
Huh?
He got nervous about due
I know,
process.
they get very nervous when you start bringing up due process. They even get more nervous when you bring up rules of court or violate rules of evidence. So they don't like that. Because rules of evidence is due process. So you switch everything. Everything they do is a violation of due process. Your Honor, that's a violation of due process. In what respect? Well, rules of evidence such and such say such and such, you know what I mean? And therefore this court has violated that specific rule. I want the court to take judicial notice of the violation. For the record, Your Honor. And if you want to say anything into court, all you have to do is say, put it on the record. You say, Your Honor, for the record. And they have to shut up and let you speak. They can't tell you to be quiet. They cannot deny you the ability to create a record. Got numerous court cases say that.
He broke that one too.
They cannot deny you the ability to create a record. No, they didn't, because they told you you could make the record, but he wasn't going to be there.
That's exactly what he said, is he got up and
He didn't break that rule. He told you could make the record. I'm not going to listen to you.
my understanding of that moment was that when the judge is not, when his butt is not touching that seat, it's not happening.
Well, you still create a record for appeal purposes.
Okay.
Yeah. He's not denying you the, he wouldn't dare deny you the ability to create a record. They know that. I'm still waiting for somebody with intestinal fortitude to do my little scenario that I always talk about. They won't let you bring tape recorders in the courtroom anymore. Some courts will, most courts won't. And you can say, Your Honor, I want to tape record this for my own personal record because I can't read and speak at the same time. The judge say, well, we don't allow tape recorders in my courtroom. Thank you, Your Honor. For the record, may I take notes as we speak? The judge says yes, and you put your head down. Mr. McDonald, what are you doing? Well, Your Honor, you gave me permission to take notes, and I can't read, think, and write at the same time, so I have to stop and write everything you say down longhand because I can't use my tape recording for personal note-taking. Mr. McDonald, you do that one more time and I'm going to hold you in contempt. Well, Your Honor, I can't afford a court reporter to be here, and I don't trust the tape recording because I've seen where they've omitted certain portions of the transcript on tape recording. So either I'm going to create a record here, or you're going to have a stenographer come in, and the state will buy me a copy of the record. Is that what you're offering to do for me? Take the burden. Huh?
Bailiff?
Well, thank you. Officer, do you want my hands in front or back? Volunteer to go. I'll be glad to go. I need 3 hots and a cot. Always be nice and polite. And I guarantee you won't spend more than an hour or so in there before the judge realizes that he made a boo-boo. You know what I mean? But judges are very honest. In most cases. But they love to see about getting you discombobulated. Highway has a specific term. The road highway means commercial way. I do not travel on the highway. I travel right up 101, 5, but I do not travel on the highway. I travel on the public easement. That's free. They can't charge you. They can't arrest you for traveling on the public easement. But they can control you on the public highway. Use of terms. Yes?
Maybe a public commons also?
Yes, that's more east. Back east they use that.
I'm just wondering about the term.
The public commons used to be the town square. Remember where the old town square where you still see some of the older towns, they have what they call a town square where everybody used to hang around. That's public commons. You could not be arrested in that area. And you're in the public commons. And you travel on the public easement. Now it's not my fault that they put asphalt and concrete on my public easement.
Or traffic lights.
Or the traffic light. That's not my problem. If they want to go in front, along in front of me at 60 miles an hour and pick up that concrete and then put it down behind me, that's okay too. But as long as they're, I'm going to use it because it's covering my easement. If they want to cover my easement, that's okay. But I'm going to use it. You know what I mean? If they want to go along in front of me and take up the asphalt and the concrete in front of me at 60 miles an hour and put it down behind me at 60 miles an hour, that's all right too.
You know what you need? You need a ticket. And I'm thinking about how to get you one.
Well, you saw what happened when I tried to get one when you were in the car with me.
That's all right.
Remember when I waved the cop through and we were arguing back and forth at the stop sign?
That's all right. I need to get you one in Van Nuys.
That would be Van Nuys. I'd take it into Van Nuys and ask for Judge Messer.
Good.
I'd say, Steve Jones sent me. You know what the first thing he's going to say? Case dismissed. Steve Jones is my number one idol.
Uh-huh.
Uh-huh. Here's a good one. Tulare versus Campbell. 57 Cal Reporter, 2nd, 851. It is presumed that the legislature, that when legislature adopts legislation, it is aware of its prior enactments. When they adopted the current vehicle code, they were aware of the Stork case. It's never been overturned. N. Ray Stork says the state has a right to regulate and control chauffeurs and commercial activity. All others are exempted. And the legislature is aware of it.
You have the cipher of the Stork case?
I can't remember. I give it away every Sunday. It's in the manual.
Oh.
In the manual, Stork case. Here's another one. This is one, new one that I just dug out recently. Thompson, T-O-M-S-E-N versus City. 56 Cal Reporter, 902. Repeating. 56 Cal Reporter, 902. Court may properly enjoin attempts to apply valid ordinance to conduct not within its terms. So you have to go to legislative terms to see who the ordinance applies to. Then you can get a declaratory judgment you're not within that, or you can get a motion to dismiss because you're not within the classification as that specific ordinance applies to. One of the key things which they've changed a little bit here was the old Los Angeles County dog ordinance. How many people here have heard the story of the Los Angeles County dog ordinance? Steve is. I had a friend of mine, he was a preacher. He since moved to Oregon. He come to me one day, several years ago. Richard, he says, I got 3 dogs and I got 3 tickets from the dog license people for having unlicensed dogs. And I says, well, it was very easy. I said, I'll tell you what to do and how to go do it. I says, go research the county dog ordinance. And I says, don't do it just for this year. Go back, all the way back to its original enactment and find out the purpose of the Los Angeles County dog ordinance. So we went all the way back to the early 1900s before we found the ordinance. And the ordinance said specifically, and it's been carried forward up until 1991, I think, is when they changed the ordinance. It was carried up to 1991. Said specifically that before a dog, anybody could be cited for having violation of the dog ordinance, they had to be signed complaints from 3 sheep ranchers that wild dogs were attacking their dogs. That's 3 sheep ranchers. It specifically said 3 sheep ranchers. They had to have signed complaints from 3 sheep ranchers. So he walked in, he come up there and he's just got all the smiles. He just showed me all these ordinances and everything. He's just happy as a lark. I said, no. He said, how do I do it? So I said, go into court and I just asked the judge where he copied those 3 complaints. So he did. This is way, you should hear him. He's got a Georgia twang to his voice, you know, and he talks real funny, you know. And He says, Your Honor, he says, do you have those 3 complaints? And the judge says, what 3 complaints? He says, well, according to the intent of this ordinance, he says, you have to have 3 complaints signed by 3 sheep ranchers that wild dogs were attacking their sheep before this ordinance is enforceable. Do you have those 3 complaints before you? He says, what are you talking about? Well, here, Your Honor, and he laid it out here. Here's a copy of the ordinance and the legislative intent of this ordinance. Bailiff, would you please give that to the judge? And here's a copy for the prosecutor. Would you give that to him also? And the bailiff gave it to the judge, and the judge sitting there reading it and reading it and reading it. He says, you did your homework, didn't you? He said, well, Your Honor, he says, I thought it was wrong. He says, case dismissed, go home. Just that simple. Had no jurisdiction. They changed the ordinance, I think, in '91. Moving the requirement of having 3 sheep ranchers. And I bet there's a lot of outlying counties that still have the same type of situation out there. But always go back to see what the original intent of any law is. Yes?
They might be able to remove the 3 sheep ranchers, but the intent is the dogs have to have killed something.
Right.
They just don't have to have a complaint. Now, what did they kill?
Yes.
Killing something's still there.
Right.
They just don't have to have a complaint.
Yeah. I bet, and how long, you're living, what, Riverside County? San Bernardino. You probably got the same type of ordinance down there. If you go back and check out your original intent. Go check the original intent. There's so many original intents that are so different than the way they're applying the law today. That's why this little site I just gave you is so important. You know what I mean? Not within the scope. Let me read that again to you. Court may properly enjoin attempts to apply valid ordinance to conduct not within its terms. If you weren't doing something that was within the terms of the...
Which one was that?
That's Thompson versus City. 56 Cal Reporter 902. It's very specific. When you do these arguments, no matter what it is, you know what I mean? Be it code enforcement, IRS, or whatever, the same principles apply consistently. What I've done is I've gone through the law books and dug up principles of law that are consistent no matter where you go, no matter what arguments you're going to use. These principles of law remain the same. The courts generally do not waver from principles of law. They always say the same. Rule that when word used in statute has well-established legal meaning, it will be given that meaning in construing statute applies not only when the meaning of the word in question is wholly or partially legal, but also applies when word has both specific legal meaning and a more general sense in the informal legal uses or in lay speech in latter event. Lawmakers are presumed to have used the word in its specific legal sense. And the specific legal sense of motor vehicle is commercial activity. So, when he wrote the vehicle code, that is a commercial vehicle code.
Or person.
Or person. It's in its specific legal sense, not a citizen. It's a slave.
What are you citing?
That's Arnett versus Dalcillo. A-R-N-E-T-T versus D-A-L-C-I-E-L-O. 56 Cal Reporter 2nd, 706. See, the legal terms are the most important thing that you can ever do. And it presumes that the legislature was aware of it. Courts are well aware of what the word citizen means. Citizen is not a person. Let's go back to that word citizen. Let's have some fun with that. In the original intent in 1776 of the Constitution, they used the word citizen of the United States. In order to be a citizen of the United States, first you had to be a citizen of one of the states of the Union. As a consequence of being a citizen of California, you were called a citizen of the United States when you went into a territory or left the states of the Union. In 1868, they reversed that trend. They created a second-class citizen called a citizen of the United States, and as a consequence of being that, you are a second-class citizen of the state. So the judge says, well, I recognize you're a state citizen. Then you come back to them, are you saying I'm a second-class citizen or a first-class citizen of the state? There's two state citizens, first class and second class. First class is the one that we the people, and the second class is the person. So always be specific. Identify yourself. As Cece was saying, identify who you are. You know, tell them who you are. Don't be afraid. And make them, force them to admit it. See, whenever in any court case that I've read, whenever they refer to sovereignty, they refer to people. The people are sovereign. So are you one of the people or are you one of the persons? Just that simple. Whenever they refer to U.S. citizens, they refer to person. Whenever they refer to the people are sovereign, the people have all the sovereignty, the people are sovereign, you know what I mean, etc. Whenever they refer to sovereignty, they say people. So I'm one of the people. I'm not one of the persons. Yes?
Recently there's been a lot of stuff in the paper about the restoration of states' rights
Yes.
in the Supreme Court because of, what were they?
Yeah. Well, there's the last, I think there's 12 of the last 13 decisions out of the United States Supreme Court, just before they recessed, were all for states' rights and state citizenship. Along those lines, they're advocating states' rights. In fact, Steve's favorite writer, what's his name again?
You talking about Tribe?
Yeah, Lawrence Tribe,
Lawrence Tribe.
who's a die-at-a-hard communist, 14th Amendment U.S. citizen. He was pro-14th Amendment. Now all of a sudden he's reversed himself. Now he's saying that everybody under the Second Amendment has the right to keep a gun. Now he's completely reversed himself, and he's got all his followers up in the hip, up in arms, trying to attack him now. He's completely reversed his position because following the Supreme Court decisions. You know what I mean? See, the Supreme Court, right now on the Supreme Court, United States Supreme Court, we have 4 constitutionalists, 1 waiver, and 4 diehard communists, socialists. Okay? These socialists over here used to be 6-3. Now it's 4-4, and we got 1 swing vote. So we win a few, and we win one. We won 12 of the last 13 court cases that advocate states' rights.
But the question is, how much longer is Rehnquist going to serve?
Probably another 5-10 years. He's going to wait until your friend Billy Boy gets out, King Willie gets out.
Well, that's going to be fairly soon. And there are a lot of people who think that the next president will be not appointing several justices to replace Rehnquist and Sandra Day. And I think there's somebody else who's getting up there.
Well, Sandra Day's took quite a few years. She's not that old.
I hope you're right.
No, Sandra Day O'Connor is one of our good ones, you know what I mean? Yes.
Richard, I understand that states now are subdivisions of the federal government. So in one sense, what does it mean to say that the states' rights prevail over federal rights?
Well, that's what they're trying to get away from. to get the states back to being sovereign within their own state and tell the federal government, take a hike. They've been telling the federal government, you can't do this, you can't do that.